Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy. The dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
Is the next search on February 28, 2020? 7:44 p.m. How does the FBI find people? The people is misspelled P-E-O-O-P-L-E.
I object.
Did the defendant find out how the FBI finds people in this case? Oh, she found out.
What more do you need to see?
Welcome back to the Court of Public Opinion. I am the Recovery Addict. Special late night stream tonight because there has been breaking news in the Melody Farris case, which I have not got to hear yet. My phone has been blowing up. My burner phone is on fire. The messages are full. We dropped the Melody Farris case temporarily while we took Sarah Boone live. We've got equipment down in Florida to follow Sarah Boone. We're going to continue doing that. But apparently, just because we left Melody Farris doesn't mean Melody Farris left us. Yes, it sounds like we were referred to, not by name, but I'll let you hear it and you tell me what you think in court. And so we're going to start with the good stuff. We're not going to do all the other pre-play stuff. We have missed a day and a half of the Melody Farris trial. This is a trial, just for those that, as the music dies out here. For those that have not followed this is a woman who is accused of shooting and killing her husband and placing his body on the burn pile in their Georgia home. Beautiful Georgia home, beautiful property. They thought it might have been an accident, finding his burned remains on the fire, until they found a .38 special round embedded in one of the remaining rib bones in the fire. And then it became a murder. In the course of this investigation and in talking about where different guns were owned, what guns were owned by whom or by who, Red Pen, correct me on that. I'm not sure which one's that correct. Somebody made a statement saying that there was a gun somewhere, and I said, that's where I think she got the gun. That's where I think they got the gun. I think it was stolen from Martha Jane. Martha Jane, I believe, is Rusty's mom. Don't correct me on this. And before we start playing this, before we go there, I have always said that we want to be respectful on this channel, because you never know when family members, victims, lawyers, or judges are watching us. In this case, one of the witnesses, Martha Jane, was watching our live stream, and she'll describe it in enough detail that I think you'll know who she's talking about. And I remember, because I also made a comment that was not carried on anyone else's area. It was my comment that she's referring to. So that's coming. She calls us Court TV, with the man with the earphones on in the corner. That's me, apparently. And I have not heard the call. But what happens is this. Martha Jane heard something I said about where I thought the missing murder weapon came from. And after hearing what I said, she put one and one together and it equaled two. And then she made a phone call. The phone call was recorded. We're going to hear it as it was announced in court, as the information came to the prosecution. We're going to jump to that. I have not pre-heard this. This is all I know. It's been nuts. Buckle up, guys. This one's a wild one. Here we go. They were at break. They were just coming back from break. And let's join them now. Deep breaths.
All right, what we got?
Judge, as you know, the state was made aware of some newly discovered evidence last week. The state informed the defense as quickly as possible of this evidence. We also informed the court of the evidence, and the state is now moving to admit that evidence for trial for the jury to hear, by way of Captain Hands and Martha Jane Barton as witnesses. Captain Hands was already under subpoena. We have now confirmed that Ms. Barton is under lawful out-of-state subpoena. She's in Tennessee. And at this point, we can call a witness if you would like to hear more foundation.
All right, go ahead.
Captain Lee Hands. The state calls Captain Lee Hands. Yeah. Your Honor, Captain Hands took a recording of Miss Barton when she called into CID, and towards the end of the recording, it's about a 14-minute recording, from 12:10 to 12:30, Martha Barton gives her phone number, and we have been made aware by several witnesses that we have unintentionally put their phone numbers on the record and so forth. I think maybe the defense did to Mr. Farris and then Addison Farris and so on. So at this point, we would ask to redact that portion of the recording. It is 20 seconds, just her phone number.
Yeah, we probably have done some things in the trial with it being broadcast that we probably should have thought about, but we haven't dealt with that for 4 years. So.
Exactly,
right.
Judge. Captain, if you could please raise your right hand. Do you swear or affirm the testimony you're about to give in the matter now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
How are you employed, Captain?
I am with the Cherokee Sheriff's Office. I am the Division Commander for the Criminal Investigations Division.
And can you actually state and spell your name for the record?
HANDS, just like the end of your arms.
Captain, were you on duty last week?
Yes.
Let me pull up specific dates and times. Are you under subpoena for this case?
I am.
And you were called out to, you were actually on scene in 2018 at Purcell Lane for this case. Is that true?
I was.
Okay. On Friday, October 18th, this past Friday, did you take a call at CID that you had to make our prosecution team aware of?
I did.
Okay, can you tell the court about that call?
It was slightly before 10 o'clock. My administrative assistant said that there was a Martha Barton on the phone, and she wanted to talk to someone that had knowledge of the case currently being prosecuted, the Melody Farris case.
So who ended up taking that call?
I did.
Why you?
I believe I was the only one in the building at the time that had knowledge of the case.
And so did you end up speaking with Martha Barton?
I did.
Did you record that phone call with her?
I did.
And have you had an opportunity to listen to that recording?
I have.
Did you forward that recording to myself, me?
I did.
And did you then inform me about who it was that just called and why you were sending me a recording?
I did.
And at this time, the state would like to publish, admit and publish M. Barton 1.
All right. For the purpose of this hearing.
For the purpose of this hearing. All right.
Have y'all got a copy of it yet?
We have it.
Okay.
It's 1409, Judge.
Go ahead, Lillian.
Captain Hands can I help you.
Who am I speaking to?
Captain Hands.
HANDS. This is Martha Barton in Tullahoma, Tennessee.
How are you, ma'am?
Have you skipped the phone number?
Well, I've got a heavy heart.
Okay.
I'm sure you're very aware of the case of Melody Farris that's going on right now.
I am.
I've seen it on Court TV.
Mm-hmm.
I'm the person that she was coming to stay with in Tennessee.
Mm-hmm.
And did her mother and I were first cousins.
I think I remember your name.
Pardon?
I think I remember your name coming up.
Well, it's been brought up in the trial too.
Yeah.
Well, Detective Polk and Hayes came to my house along earlier the TBI came. They never asked me if we had any guns. Rusty Martin, that testified yesterday and the day before, is my stepson. My husband died 10 years ago. But he and I have had a close relation. He's been very good to me, offering to do things for me. And he's the one that had a relationship with Melody.
Yes, ma'am.
But they never asked me if we had any guns. And I thought that was very strange because my husband was a hunter and we had a very large gun safe in the garage but of course they were never out. This may be long. I hope I don't go around the bush to tell this. But anyway, I think in 1979, we built in 78. I think it was in 1979 for Christmas that year. My husband gave me a 38 snub-nose special. I never shot the gun. Roy went hunting. I never paid any attention to his guns. In fact, when we married, I was absolutely terrified of guns. And I guess I got over that a little bit, but never to the point of handling them and doing anything. When he gave me that gun, he gave me a $100 bill rolled up and put in the cartridges. And he made a joke. And Rusty was here. It was at our family Christmas, and he gave it to me. Said if he hadn't given me the $100 bills, he'd have never gotten away with giving me a gun. It was put in a drawer, different places. I even bought him a .357 Magnum. I couldn't tell you for Christmas one year. I couldn't tell you what that gun looks like, and it's in our safe. I couldn't tell you if it's chrome. I couldn't. I'm sorry. I just don't know. Okay. And if it were a purse or shoe, I could tell you. But anyway, the .357 Magnum, my husband was sick and at home when Melody came up to help us take me to Nashville to doctor's appointments. And at that time, Roy had gotten sick. Before that, because he had a stroke and he had Parkinson's.
You're talking about Roy, your husband, not Rusty, right?
Right.
Okay.
Before that, he had kept his .357 Magnum in his closet on his side of the bed. His closet's on his side of the room. And he had gotten mine out for me to keep on my side for protection. Now, I believe the shells, they were never loaded. And I think the shells to my gun were, I don't know if they were in my closet or not, but my gun eventually ended up underneath my nightstand because I just didn't like having it in my closet.
Okay.
And my closet is about like Fibber McGee's closet anyway. And so sometime after he passed away, Melody wasn't here at the time. And I don't know why I did not put those in the gun safe, but I didn't. There was in one of the spare bedrooms upstairs, there is a chest at the foot of the bed when it's against the wall. And I put those 2 guns in there. I put a TV on top of it, and I don't even know what all, but I had stuff piled up on that I thought nobody is going to move all of that stuff to get in that chest. I was very weak one day when she was here, and I told her for several things were that I shouldn't have, but she had a way of, well, she was family. And I told her where those 2 guns were. Well, after she was arrested, I had someone come out and take a lot of things that I had gone through and stored in this particular bedroom, just in the floor and everything. And I wanted that TV taken, all this stuff taken to Goodwill. And while he was here, I said, would you look in that chest and see about those 2 guns? And he did. The .357 Magnum was there. My .38 Special was gone. I have also searched this house over to see. I mean, I know I'm not senile. I'm in very poor health. But that gun is gone. It was brought up in Rusty's testimony day before yesterday that his daddy had a .357 Magnum, and I almost believe that he said that I had the .38.
Yes, he did.
Because I was watching it, and the one that I was watching it on was the court TV, and there was a man down in the corner that would make comments, and he had the earphones on and everything.
That's me.
And when that was said, he said, that's where she got the gun. And I think that he would come, I think he called my name. My heart, I have felt so guilty ever since I realized my gun was gone. And then when it came up in court, I think that you all can go back and listen to that and realize that there is another gun. And another thing, it was in a little leather holster. And Scott found that gun, and she took that from my house. I was in the hospital 3 times, I know, from the time my husband died. I had heart surgery. And then I was in the hospital here in Tullahoma. I'm pretty sure it was 3 times. I know 2 times that my blood pressure dropped. And she was here, and she had access, and Rusty mentions in his testimony.
Okay, I can't talk about the testimony, though, because I'm under subpoena.
Okay, well, if you all can go back and listen to it, can you do that?
Okay. Now, was your gun in a holster?
Yes, it was in a holster.
Okay, a leather holster?
I guess that's one reason that I don't even remember if it was dark, chrome, whatever.
Who?
I'll check.
Okay, go ahead. I'm so sorry, Miss Barton. Who was the guy that came over that you told to look for the guns after the arrest?
It was my nephew.
Okay.
But I really don't want him involved.
I understand.
He's involved now.
I am going to, and you've checked other places for the gun since, is that correct?
I have looked this house over. That gun is not here. And there were some other things that I told her that disappeared when she was here too, that she is the only person, she was the only person in this house. So I don't have a family. I've got a niece and nephew, And we were split up over Melody too. It just about broke our family apart. Her coming up here, and I think they were in contact with Chris and Scott and knew about Rusty. Honestly, I did not know that was going on. It made me sick to listen to the testimony. I don't even feel like I can go out of my house. I don't get up that much anyway. But hold my head up and tell Homer, because I don't know who knows this. I am so embarrassed.
Well, there's nothing that you did, so, I mean, there's no reason for you to be embarrassed.
I know, but it's the Martin name. I'm just sick.
What's your phone?
I didn't sleep a
1212.
That's the phone number they extracted.
Replaying at 12:30.
The legal team that's currently prosecuting the case, so they may give you a call later today, okay?
Okay.
Would that be okay with you?
Yes,
Well,
I'll be here.
I'm sorry for your heavy heart, but I do appreciate you giving us a call.
Well, I just felt like by not telling this that I was almost aiding and abetting. And I know from the get-go she started throwing Scott under the bus. And I can't imagine a mother doing. I'm not a mother, but I cannot imagine a mother doing that.
Did she ever say anything untoward about her husband?
Pardon?
Did she ever say anything untoward about her husband?
Oh, she despised him.
Okay. All right. Well, I'm going to send your number and your information over. I wish you would feel good about walking around your hometown. You didn't do anything untoward or unethical, and you can't help the actions of other people.
Well, I know that, but I'm 84 years old, and I don't need to be going through this.
No. We'll hope it'll be over very shortly, and we'll take it one step at a time, okay?
Okay. I appreciate it.
Thank you so very much, ma'am.
Thank you.
Bye-bye.
Captain, was that your complete conversation with Miss Barton?
Yes, ma'am.
Did you speak with her again after that phone call?
No, ma'am.
That's all I have for you. Thank you.
All right, Sweeter.
Just briefly, how did this phone call get directed to you?
My administrative assistant came to my office and said there's a Martha Barton on the phone that wants to speak with somebody that knows something about the case.
Okay. And that would be, you would know something about the case because back on July the 5th, 2018, you were actually in charge of this investigation, the entirety of the investigation.
Well, I would say the captain was in charge of the investigation and then the lieutenant was in charge of the investigation, but I was in charge of parts of it, yes.
Okay, and you assigned...
Oh, I'm sorry. Go ahead, sir, I apologize.
Well, there's been multiple witnesses testify that you gave them assignments in the case.
Surely.
Him included.
Surely.
So you assigned him as the lead detective of this case?
Correct.
Correct. So what involvement have you had in this case ever since?
Since when? Since July 5th?
2018.
Until we would do periodic hot washes, reviews of what we were doing, where things were going, what evidence was coming in, and since 2018, after the arrest warrants were complete, then it was pretty much just Detective Hayes, or now Sergeant Hayes, finishing his narrative and keeping in touch with the prosecutor's office.
You used a term of art that I'm not familiar with. You said hot watch?
Hot wash.
Hot wash. What is that?
It's basically a debrief, seeing where you are evidence-wise, investigative-wise.
Okay. Anything else for this witness? Michael?
Thanks, future.
That's all, Judge.
All right. Anything else?
No, Judge.
All right. You sit down.
Thanks, sir.
Have y'all had other conversations with her?
So, yes, Judge, our office did reach out to her. Investigator Moore spoke with her. She She put together a report of a summary of their conversation, which we provided to the defense last week as well. And that was on the same day, same Friday, at, let me see what time that was sent. That was later in the day on Friday the 18th. I don't know how to get it.
It was 7:36.
Thank you. More information. Thank you. Yes, 7:36 p.m. Investigator Moore had sent her supplemental report regarding her conversation with Martha Barton.
All right, y'all got a copy of that?
We did.
Yeah, is any additional information disclosed in that?
So additionally, she kind of, Ms. Barton provided a timeline and stated that her, when her nephew came to help her, she realized it went missing around that time, which was in September of 2019, shortly after the defendant was arrested. She also, let's see, she ended up telling her cousin, who is the defendant's mom, Kay Walker, about the missing firearm. She did not necessarily give an estimate of when she did that, but she stated that she ended up telling her about the missing gun. She provided that when Martha would speak with Melody in the jail, she would say, "I love you" to Martha Jane at the end of the call, and then shortly after telling her mother telling Kay Walker about telling Melody's mother, Kay Walker, about the gun, she stopped telling Martha, "I love you." She never confronted Melody about the missing gun. I think that was summarily the new information that we obtained.
Right. And y'all have subpoenaed, effectuated service of subpoena at this time, is that right?
Judge, I'm sorry, can I have one second?
Or
We have some more information too.
all right.
We spoke with her again today, this morning, and I say we, Investigator Moore spoke with her again this morning, so she's going to put together a report for that. But also,
Y'all want to just
put her on the stand now?
All right.
oh yeah, Investigator Moore, sure.
Go ahead. All right.
Yeah.
We'll all find out together.
No, we know about it.
Yeah.
We don't.
If you could raise your right hand. Do you swear or affirm the testimony you're about to give in the matter now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Okay, have a seat. Please tell the court your role in the DA's office.
Yes, I am a SVU investigator, Monica Moore.
Are you assigned to this team here for the case against Melody Farris?
Yes, ma'am.
Have you been assisting putting the trial exhibits together and speaking with witnesses?
Yes.
Friday, the 18th, did you have the opportunity to speak with Miss Martha Barton?
Yes, I did.
And did you, after that conversation, put together a report and provide that to the defense attorneys?
Yes.
And did you have the opportunity to speak with her again today?
Yes, ma'am.
To follow up with her? And
It's also the sound of theirs going down. Just speak up a little bit louder.
Yes, sir.
what is it that she told you today?
Today she said that her niece Jennifer has been helping her because of her health issues, but her niece wanted to make sure that the gun was not in the safe, and so over the weekend her niece came over and they checked the house over. They looked for it and they went into the safe and they found that the gun was not there. And that they also found some other items, some bullets that went with the 38 special bullets.
Okay. So the firearm, they looked for it over the weekend, essentially,
Yes.
her and her niece?
Yes.
And they still could not find it?
Correct.
Okay. Was there anything else that she told you that was new information from last Friday?
No, on Friday she did say she described the box of ammunition as red and white box with a TG and Y sticker on it. She remembers that her late husband bought it probably from that store up in Tennessee.
And that was in your report that you provided on Friday?
Yeah, but no new information after that.
Okay, that's all I have for you. Thank you.
Thank you.
All right. Mr. Weaver, Mr. Ware.
Do you know anything about the manufacturer of the bullets? Does she have that information?
She did not have that information.
That's it.
All right, so I've got the sound bite ready
I'll
for you.
direct her to reading whatever she had with her.
That triggered
They
Martha
offer-
Stewart.
I have told her to just keep everything there and keep it safe and yes.
All right, anything else from this witness?
No, Your Honor.
All right.
Did I say Martha Stewart? Martha Jane.
All right, you sit down, thank you. All right, anything else from the state on this issue?
I don't believe so, Judge.
All right. Argument?
We're asking the court to exclude.
Of course they wanted to exclude it.
John, you've got to pull
You have a compelling reason. You have a compelling reason why I should exclude it.
And honestly, I don't think you can exclude it right now. You want to? Why don't you argue? Yeah, as we all know, normally when you violate the sequestration rule, typically what the court ends up having to do is just giving a curative instruction to the jury at the end that it goes to the weight, not the admissibility of the person's violation. It's obvious from the audio recording that she did violate your court order, that she's not supposed to be watching it. My assumptions would be is that she has watched the entirety of the trial. Otherwise, she wouldn't know when Rusty was testifying, considering he was here, from my understanding, the entire week of last week and didn't even know when he was going to be called. He was essentially just at a hotel on standby to be available at any point in time. Under the case that I found this morning, it's State versus Brown, and it is 354 Georgia App 493, the 2020 case. States that the court actually does have another option instead of just giving the curative instruction. It says that where counsel or the witness violates the rule intentionally, the court may strike testimony already given or disallow further testimony. The trial court's denial of a mistrial for violation of the sequestration rule is a matter of discretion and reversible only on showing prejudice. What ended up happening in the Brown case was there was a whole issue of whether or not the rule had even been violated at all, because it had something to do with two witnesses overhearing the judge behind closed doors. But that was actually never proven, and the court just ended up coming in and saying, I'm declaring a mistrial at this point, of which nobody essentially was requesting. Obviously, the defense was on board with it at that point, but the mistrial was overturned. The court, in making a statement that it is actually restrictable, was quoting the U.S. I think it's a Fifth Circuit case, Ferdin versus Land Sea Services, which is a 1993 case out of the Fifth Circuit. As discussed, and in that case it said there's no evidence showing that either the defense witnesses would have changed their testimony to match other witnesses. So it seemed like when you look at both of them together, well, actually, let me go into that part. So that was the Fifth Circuit case. The Brown case went on to state, instead the trial court should have chosen an intermediate option, such as allowing cross-examination of the witnesses regarding the possible violation and instructing the jury that a violation of the rule should be considered in evaluating their credibility. So that is that. Yeah. The way Millich
is interpreted out of the Brown case.
Is taking it out of the Brown case is that under the pre-2013 statute, the witness could not be disqualified for testifying as a result of a violation of the sequestration order. The new evidence code, although the sanction is rarely used, the trial court may treat a violation of the sequestration rule by citing the guilty party for contempt, allowing opposing counsel to cross-examine the witness as to the nature of the violation, or 3, striking the testimony already given or disallowing further testimony as a rule has been intentionally violated and actual prejudice results. I don't think there's any doubt that we would be prejudiced by this, considering we got this evidence on Friday. There's also another witness that she names in her recording, being her nephew, that he's out of state. We might need to subpoena him, but we're in the middle of the trial now, and this has now just become an issue, even though Ms. Barton has been interviewed now by law enforcement on 2 separate occasions. And the court can clearly hear from her interview, she actually does not come up with this new theory of the gun on her own. She said that the man on court TV, the one wearing the headset, said that's where she got the gun. And that's where she got the idea from. So her testimony between the 2 interviews has completely changed. She's never, and she freely admits that she's never told anyone about this gun being missing, even though she's known it's been missing for the past 5 years. So the state wants to bring her down here, put her on the stand, say Melody stole the gun, even though there's absolutely zero evidence of that. And in fact, if the court allows it, in her other interview, we're going to show where she was talking to Detective Hayes and Detective Pope, talking about, at length, about some boy who lived next door and was helping her husband and had broken into their house. So I think this, if there ever was a sequestration rule violation that needed to be excluded, this would be it. But I think, in all fairness, I think the court and Ms. Farris's counsel will have to hire Ms. Barton to see what all she is going to say, because obviously that small audio recording is not all of it, to get to the bottom, especially of how she knew when Rusty was testifying, how much of the trial she has watched. Because my belief would be that she's watched the entire thing. She watched Scott's testimony, because there's actually some conversation in there about Scott and Chris as well that the court heard. So for that, we would ask the court to exclude Ms. Barton's testimony.
All right, Stokes.
Thank you, Your Honor. Counsel, the issue is whether or not there's been a violation to the degree that she cannot testify. Judge, the first thing I want to cite to the court is OCGA section 171610, and that's the code section that says both parties can rely on materials and information furnished in the discovery, so both sides don't have to turn over the same thing. 171610 also says that either party may call as a witness any person listed on either the prosecuting attorney or the defendant's witness list. We have listed her several times on witness lists, I believe, and also information going to the defense. We kind of kept her, we did not subpoena her, we kind of kept her, we talked to her before trial, and I think we actually talked about that if we needed her, we could do Zoom or something along those lines. So she was not under subpoena for us. I'm assuming, and I'll let the defense say if otherwise, that she was under subpoena for the defense. If she was not under subpoena for the defense or the state, then she's technically not in violation of the rule of sequestration. And I know, Judge, when we argue the law, sometimes we have to argue the technicalities and the precision of it. And so I think she would not be in violation of the rule. That being said, I don't think...
And
no, we
y'all had her on witness list, but had not
under subpoena. They had her on her witness list.
Y'all had her on call, I expect, and talked to her.
And we talked informally that if we needed her, we would agree by Zoom. But Judge, I think so. She's not in violation of the rule. The second argument is that
there's the issue of one. It's new evidence that hadn't previously been disclosed. Then there's whether or not there's sequestration issue.
Yes.
All right.
The second statutory law, I'm going to get some decisional law in a second, but OCGA section 1716.4C, and that is the code section that deals with newly discovered evidence during trial. We actually have the code section on it. It says, if prior to or during trial, a party discovers additional evidence or material previously requested or ordered which is subject to discovery, and it goes on to say, such party shall promptly notify the other party of the existence. Judge, as soon as we found out on Friday, you may have noticed that we were sitting here in court, and we let them know and told the court we had some we went out and discussed it, gave them the information, gave them the recording, and we've been nothing but candid with them and prompt with them. So I don't think it's any violation whatsoever. And then there's several cases that talk about Williams v. State, 261 Georgia Act 410, 2003. It cites newly discovered evidence is not in violation of the 10-day discovery deadline because it is newly discovered. Dixon v. State, 252, Georgia App 385, 2001 says no violation because the evidence was newly discovered and was revealed as soon as practicable after its discovery. In fact, the court in our system, as Your Honor knows, State v. Roberts, 247, Georgia 456, a 1981 case. The court, outside of all this newly discovered evidence, even if it was not newly discovered, that is the case, the Roberts case, they reopened the evidence during jury deliberations at the request of the jury. So the court has the ability to reopen evidence at any time and has that much discretion to do it. But when it comes to newly discovered evidence, it's a different rule, and there's been no violation whatsoever of that. And Mahogany, M-A-H-O-G-A-N-Y v. State, 366, Georgia App 750, 2023 case. So under the new rules of evidence. And it literally says, further, a violation of the sequestration rule affects only the weight and credibility of the witness's testimony, not its admissibility. That's Mahogany v. State, a 2023 case. And then Park v. State, 314, Georgia 733, a 2022 case. It says, Park holds this. The Supreme Court stated, a party's remedy for a violation of the rule is to request the trial court to charge the jury that the violation should be considered in determining the weight and credit to be given the testimony of the witness. When you look at this, I think there is no technical violation because they were not under subpoena, but in all candor to the court, she was a witness that could have been called by us. I do not think there's a violation that requires the court to charge the jury. I understand if the court charges the jury, there's nothing in this case to prevent her from testifying. And I know defense counsel has a job to do, and I know that this is evidence that should concern them. But I do not think they're telling the court that there's bad faith on part of the state. And the only way to cite counsel for the witness would be showing that there's some type of contemptible conduct by the party. And I can tell the court that that's not been done in this case. So I think they haven't... I think the court has great latitude and has, in fact, great discretion without it being newly discovered. But because it is newly discovered and has come in during trial, I ask the court to allow it.
Anything else?
Yeah, just to respond. In terms of it being newly discovered evidence, it's admissible. I mean, we're not really arguing that. We're arguing more the sequestration. If the court does end up allowing, what we're also going to be asking for is not for you to just charge the jury at the end, but prior to her testimony, state that, she was, you can fashion it however you want, but, something along the lines of, she was a potential witness, witnesses aren't supposed to be listening to other witnesses' testimony, and it's going to be her testimony that she listened to other people, so that can go, to her credibility, or however the court wants to word that.
All right. And what y'all's plan is to have her here Thursday morning?
Plan to have her here, I think, Wednesday evening, and have her here Thursday morning.
Right. Thursday morning for testimony.
And we'll be glad to make her available to you.
Yeah, I'd say I'll give y'all a chance to talk to her. Maybe we do that. I'll think about that.
We could have her as soon as 8 o'clock on it.
Yeah, that might be the
Thursday morning.
Yeah, I might have y'all.
I think the proper procedure is voir dire. We have to do it.
Voir dire.
Well, I'd let y'all talk to her, and then if we probably need to.
This judge needs to know that there's only one channel to watch if you're watching the.
They may need to do the same thing with her prior to the jury with the evidence and let her testify as to what the evidence would be.
How much a motion to eliminate?
Yeah. And then if y'all want to present me a proposed charge, I'd consider it, although I may not. I'll look at that. But y'all definitely can cross her about all that, and that she was a potential witness, and then whatever this other issue you said about whether or not someone else potentially took it, that's also something you could look in, question on.
Big buffer.
But I think based upon everything that's been presented, I'm going to allow it. I'll consider some sort of limiting instruction if y'all want to put one together and let me look at it. I'll consider that, and we'll talk about that more on Thursday. We could probably have the jurors report a little bit later on Thursday morning, give y'all a chance to talk to them, put it, whatever testimony is going to be on the record prior to bringing the jurors in, go over anything else we need to discuss before we present that evidence, and then go from there, although we have, and then we have the afternoon plan at the moment. All right, anything else?
Well, we have one more issue.
Yeah. I provided, sort of to pick up where we left off on Friday, I provided both the defense and the court sort of a rundown of the digital evidence within Ms. Farris's presentation.
So we're gonna kill our audio from there. I'm gonna take you guys back to what I said. The man in the corner, because I think we've got that queued up here on channel 8. So we're gonna jump really quickly to this was day 8, part 2. Thank you, everyone. I had like 1 million people searching for this to find this clip, and thank you to all those who found it. I'm gonna turn my picture off, so I go boop. Yeah, this is me with the awful pause face. This is what Melody, let me turn it on again. What you're about to see is what, excuse me, not Melody. This is what Martha Jane was watching on our live stream that triggered her, I guess you could say, conscience to say, I need to tell them about the missing 38. I need to tell them about the missing 38. So we're going to play that. I, as you can see, am the man in the corner, and this is the comment I made during Rusty's testimony. She had access to the gun.
Did the defendant help Martha Jane with her property and things in her house?
She did. That's what they're setting up. Melody got the gun from Martha Jane's house.
I want to talk to you about the defendant.
So that was it. That was it. That was me saying that's where they're setting up. Melody got the gun from Martha Jane's house, and that's when her conscience just got the better of her, and she made a call to the detective. So now I'm not just Recovery Addict. I'm also the man in the corner with the headphones. I do more than look good. Occasionally we solve cases. So that is wild. It is wild. It's not over yet. Clearly it's not over yet. This case is ongoing. Martha Jane is going to be in court Wednesday night or Thursday morning. I couldn't tell. I think it's going to be Thursday morning, and she's going to testify. Now, when she testifies, they're going to say, you know, this technically didn't really sort of borderline broke the rules of sequestration because she was a potential witness. She really shouldn't have been watching, but they weren't going to call her, and so she wasn't sequestered. So technically, she didn't break the rule. She was watching on our channel. One more reason we say we never know who's watching. Please be kind in chat. We don't know who's out there, and in this case, Martha Jane was out there. And when she heard me call out her name, as she said on the call, and say that's where they got the gun, that's where she got the gun, then she made the call. This is not something new to her. I did not alert her to the fact, oh, your gun might be missing, go find it. That's how somebody portrayed it to me. No, she knew the gun was missing all along and hadn't said anything about it. And it's her conscience that was getting the best of her. And so, 84 years old, and she's, I'm not going to say she's on her deathbed. She's lived a full life, and she's not doing well health-wise. She says, I can't let this be. I can't just leave this out there. And she made the call. Wow. That was that was incredible. No, there's no chance I'm going to be subpoenaed. The state didn't address the one issue that really the defense did bring up, which would be, and I think they're going to bring it up when she's on the stand. And this is going to be probably their best attack on Martha Jane's testimony about the missing gun, is that she got the idea from me. Right? And that it could have been all these other people that stole the gun, but she got the idea from me. That's their best defense. But I don't think, I think it'll go to the weight of her testimony when she says, it was my guilty conscience. I knew about it all along. I just hadn't told anybody. So now we have 2 cases to follow. That's where we're going to leave this one tonight. You guys, I told you we're going to catch up tonight. I can't begin to tell you. I am shaking my eyes. I can't focus. I overdid it over this weekend down in South Carolina, clearing hurricane damage stuff. It was a blast. I loved every minute of it. It was wonderful. Got to help some great people. Got to hang out and go camping, which I don't like anymore. And I am just exhausted. I cannot burn the candle at both ends, or else we'll just have down days, and I'll miss court. So I can't do a live stream the rest of the way. I wanted to give you that bit. We will be catching up with the Georgia v. Farris trial. Before you know it, Sarah Boone's going to be done. The state's going to rest tomorrow morning. Defense only has maybe 3, possibly 4 witnesses. One day, done. It's going to be quick. So we'll be back to the Georgia v. Farris case very soon. Thank you, all those who blew up my phone to say you need to listen to this, because the man in the corner with the headphones apparently makes an appearance, and I probably will again. She gets on the stand and testifies about how this all happened. So, wow. One more just recommendation, please. First of all, thank you for being nice enough in chat that a wonderful 84-year-old lady could come in here and find a place to watch court that she'd be comfortable watching. And I love that. I love that. Thank you all. That is amazing. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe. We will have again tomorrow morning with Sarah Boone. Continues. We have our crew down in Florida, in Orlando, at the court. We'll pick that up in the morning, and before you know it, we'll be back with Georgia v. Farris as well. Have a good night. Thank you all. We'll catch you on the other side.